Alrighty, looks like we are live. I'm George Simons, one of the founders of Solo Suit. Let me know if anything's not working, if audio or visual is bad. Looks like things are good. I'm here with John Skiba, the legendary consumer warrior. Happy to have him on our webinar once again. If you missed him last time he's here, again, very glad to have him here. John, I'll let you go ahead and introduce yourself.
Yeah, George, thanks for having me back. Excited to be here. My name's John Skiba. I'm an attorney in the state of Arizona, and I practice in the areas of bankruptcy. I do consumer bankruptcy, and then about half of what I do is debt defense, is what I call it, helping people who are dealing with, wage garnishments, debt collection lawsuits, kind of defending those types of things. So I'm also founder of the Consumer Warrior YouTube channel. It's a YouTube channel I started about 10 years ago. And I just started putting videos up, trying to help people with some basic information. I always say that when you're dealing with these debt things, we always go to these worst possible places in our mind. And I found that just having a little bit of information, knowing that you're not going to go to jail with credit card loan, can give you some peace of mind and also help you put a plan together. And so that's really why I started doing videos like this, is just to provide some information, some basics of what people can do who are dealing with some pretty tough situations. So that's kind of me and what I do.
Fantastic. Looks like some people are telling me there's a little bit of an echo. Big echo happening, huh? Let me try to...
The tech side of it's always
hard to fix that. All right, maybe the echo is gone now. If there's still an echo in the chat, just go. If there's still an echo, let me know in the chat. Looks like there's still an echo.
You want me to try muting?
No, I think you're okay. Because there's no echo on our video, John. John, go ahead and talk now.
Yeah, I'm not hearing any echo on my end either. So it must be going through the... says I'm echoing.
Is the echo taken care of from John now? Yeah, I think we're good. Yeah, let's. I think we should be good now. All right. Well, thanks, John. Let's go ahead and just try to dive into some of these questions. As you folks may know, we reserve most of the time for Q&A, so I'll get to these questions in the chat. If you have a question, put a question into the chat. Hannah, our wonderful assistant, is also going to be responding to the questions through text, and then we'll be getting to hopefully all of the questions verbally here in the webinar. We wrap up about half past the hour. As a little disclaimer before we get into it too much, I just want to make it clear, Solo Suit is not a law firm. I'm not a lawyer. We're not your lawyer. John is a licensed attorney in Arizona. However, he's not your lawyer either. This isn't an attorney-client relationship established here. We're just doing a webinar. We aren't giving legal advice, all right? So I say that mostly just because of regulations. I'm sure all you guys understand that. So let's go ahead and jump into one of the questions here. Claudia, I got a summons that same day. I sent out an email to try and settle. Haven't heard anything back. Maybe they'll try to drag it out. I'm thinking to send my answer to the court soon. I'm not sure. Let's see is there a question in there? Maybe they'll try to drag it out. I guess, yeah, John, what do you think Claudia should do? So she got a summons, and then it looks like she sent an email to try to settle, and she's wondering if they are going to drag it out, and she's thinking about sending an answer to the court. Sounds like. What do you think she should do here?
And let me know if we're still getting that code. Sounds like we might be. Hopefully not. Well, I mean, my recommendation is always, if you're sometimes sending an email to a debt collection law firm, it's like throwing a letter into the Grand Canyon, kind of thing, where you may or may not get some kind of response. My recommendation is always when you get served, look at the summons, see how long you have to respond to the lawsuit, and then put that in your phone, put a reminder. You don't want to miss that date, is the main thing. If you haven't got some kind of engagement as far as negotiations, if they're not responding to it, if you can't get them on the phone, when in doubt, file your answer. That answer is going to, because if you let a default happen, it's hard to unwind that, particularly if you were served properly. It's going to be super hard to unwind it. So my recommendation is, unless you have the settlement done, tied up, signed, everybody's agreed to it, always file an answer. Because that'll protect you. You can still continue to negotiate. But when in doubt, file an answer is my typical advice on that.
Nice, that sounds good. All right, so file an answer. Yeah, and our general take that our app helps walk you through is to, once you get a summons and complaint, you file an answer, and then that gives you leverage to settle, and then you can use our service to offer a settlement. All right. I am says hi and thank you. Love you indeed. He's got a question. Figured I would just drop this here question. Is it okay legally to just leave process served documents on the ground in front of your door, not in an envelope where everyone can see? Sounds like he may have been served like this. John, what do you think?
The issue of accepting service, I always joke on my channel, this is where I get the most hate comments from people is, a lot of people are like, oh, should I accept service? Should I not accept service? My general position is you should just accept service. Just deal with it head on and put a plan together to file the answer, whatever it is, rather than risk the fact that, because this question of, okay, the process server came by, they knocked on the door. No, we didn't answer the door, but they just taped the door. They left it on the doorstep and said, you've been served. They're going to go to the court and file a certificate of service or an affidavit of service and say that you were served. And so usually in those situations, from what I've seen, it's where the process server knocks on the door. Someone is either on the other end and, they're talking through the door and they'll just leave it there. Does it count as technical service in most jurisdictions? Maybe not, but it's one of those things. Again, I think you got to be careful of erring on the side of caution a bit here when it comes to service of a lawsuit and acceptance of service. First of all, I would say just accept it. If they come to the door, just take it and deal with it. I know a lot of people disagree with me on that, but I can tell you I've seen it go south and really bad for people who are trying to avoid it both intentionally and unintentionally. And if it's on the ground there, I would just say, you know what, I got it. I've got my 20 or 30 days or 14 days, whatever it is, and get an answer filed rather than, kind of try to play that game a bit. So I don't know if it's, in that jurisdiction wherever you are, if that's authorized. Sometimes they can get orders for what's called alternative service. And in Arizona, we're even seeing judges right now allowing them sometimes to email the complaints and summons. And that counts. So you may not be aware of kind of all that led up to the process server doing what they did. So it may be legitimate, it may not be legitimate. My advice is if you have it in your hand, I would treat it as if you've been served and make sure you respond in the appropriate time frame.
Great. If you treat it as you're being served, as if you have been served, can you bring up improper service as a defense in your answer? So let's say you put together an answer, can you bring that up as a defense somehow?
If you file an answer, you're going to waive the service issue. If you come in and file your answer, the court's going to say clearly, because the whole purpose of service is to give you notice of the lawsuit. And so if you file an answer, the court's going to say, well, clearly, you have notice because you filed a response to it. So that's likely not going to be an issue. To me, service of process becomes the bigger issue. If you find out you have a default judgment against you, then you can go back and look and see, did they do service correctly? But if you've got the service, you can still have a chance to file a response. I think that better safe than sorry just to go ahead and file an answer.
Sweet. Great. All right, we got Janice. Already received the summons. The information to the attorney was incorrect and misleading. I made the courts aware and responded using solo suit services. Now I am waiting. I guess maybe they're wondering what's up next. Information from the attorney was, well, looks like you're just making a statement here. I think you're good to go. Let us know if you have any questions. Let's see, we got Zachary. I have a question. I'm having an issue with Weltman Group. They're calling me and I have no suit yet, but they keep calling me. What should I do?
If you're dealing with, there's some situations like with the Fair Debt Collection Practices Act, the FDCPA, this federal law that essentially tells debt collectors what they can and can't do. If they're calling you, before 8 a.m. or after 9 p.m. at night, that can become an issue. I usually tell people to keep logs of things like that. If they're being really annoying and harassing, if they're calling, if they're threatening you. I'm familiar with the Weltman Group. It's rare where you're seeing established debt collection firms and debt collectors, the agencies that are just totally off the rails. I don't see that a whole lot. It's something if it's something that a lawsuit's probably heading your way, I don't think there's any harm in reaching out and picking up the phone and seeing it. If anything, you can do something like a validation. I know through solo suit you can do a debt validation request. To me, those things are really helpful because particularly if you're dealing with like a collection agency or a junk debt buyer, you're going to get some information back. They'll tell you exactly kind of not only who you're dealing with, but the strengths and weaknesses of maybe the case that they would have against you down the road. Not only that, under that same law, that FDCPA, if you go to solo suit, I know they have this debt validation service that you can use. If you do that, once you send that out, while they're responding to that, they've got to stop all collections against you. So it can give you a little bit of breathing room to kind of regroup and decide what you want to do from there. So,
is the debt validation letter, is that a blocker to settlement?
Sorry, is it a what?
Is it a blocker to settlement? Does it can you send the debt validation letter and then try to settle the debt?
Yeah, no, absolutely. And I think particularly, I run into people in my practice here in Arizona who genuinely have no idea who they're dealing with. They get lawsuits and they're like, absolute resolutions or LVNV funding. They're like, I never had any contact with these people and I'm getting sued. And the same thing is with some of these collection agencies. You may have no understanding of who you're even dealing with. And there's enough, scammy stuff going on the internet that obviously, you don't want to reach out and just give these people your information or even try to negotiate paying them something. So I think the validation letter can actually help facilitate settlement. And legitimate collection agencies and law firms, one, they know they have to respond to it, but two, I think that they can see that as well, that this may be something where, okay, at least you're engaging, we're going to provide you with what we have, and then you can look at it, and then maybe we can come to some resolution at that point.
Fantastic. Let's see. Timothy, kind of a question here. He's saying, my summons was sent to my rental, which the rental did not say he knew me. I was never served directly. In this case, this is kind of coming back to the improper service question. Should they just consider this service, move forward and respond?
It depends on if a judgment has been entered, I can tell you the situation I see a lot is maybe a default judgment's been entered and then you see service like that. Now, the service rules are going to be different from state to state, but example, for in Arizona, service counts, they have to serve you in your residence where you live. So in a situation like that, if it's not your home, if it's a rental property you own, that doesn't count. Or they can serve someone who lives with you. So even if they come to your house and they leave it with your buddy who's just there watching the game or something, that doesn't count. So things like that can be helpful, particularly if judgment's been entered and you're trying to file a motion to vacate judgment, say the service wasn't correct. it is one of those gray areas where, okay, they served your friend or they served the person in the rental. You now are aware of it. The problem that I see with not responding or at least engaging in some way is that the process server is probably going to go back to the court, file a certificate saying, yep, I served him, judge, and then the clock's ticking for that answer to be filed. So you may be saying, hey, I wasn't served, but that's, if you just sit back and wait, you might end up with a default judgment, and then you're in a much worse situation. So if you have actual notice of the lawsuit, whether you have it, a friend has it, and there's no judgment, there's still have an opportunity to litigate the case, I say, to me, the more prudent course is to go ahead and file an answer. You're going to buy yourself some time. You're going to be able to present any defenses you have and either get a lower settlement or maybe you get the case thrown out, depending on what those defenses are, rather than just kind of rolling the dice and hoping that the whole thing goes away.
Nice. Yep, that sounds good. When in doubt, file an answer, protect yourself. Got another question here. Edwin, I recently used Solo Suit to respond to a lawsuit from a lender by requesting the civil court. Let's see. Responded to the lawsuit and then requested the civil court judge move for arbitration. Unfortunately, the lender filed for arbitration too. I don't think that's necessarily a problem if you filed for arbitration as well. But John, what's your take on the arbitration process? Can you kind of explain that, when someone should do arbitration, and also, especially if you file a motion to compel arbitration and it's actually granted, what happens?
Yeah. So, filing a motion, I always say this, filing a motion to compel arbitration, it often does position the case where sometimes you can get a settlement or even a dismissal. I've had that many times, largely because the creditors, a couple of reasons I see. One is most law firms that are handling collections, they do huge volume, and they have some pretty, tight systems as far as how everything plays out. And so you're kind of throwing a wrench into that system if you're pushing them into arbitration and they don't want to be there. It's also very expensive. The filing fees for consumers are not, they're usually a couple $100, like with the American Arbitration Association, but for the business, they're a couple thousand or more, depending on, a couple different factors. That being said, I always say if you're going to file a motion to compel private arbitration, you've got to do so in good faith, knowing that they may follow you into arbitration and say, yeah, let's do this. And so if you need to be prepared for that, to me, there are other reasons besides those first two that I mentioned too for going to arbitration. In my own opinion and my own experience, the courts, the small claims courts, justice courts that handle a lot of the collection suits, over 95%, nationwide, the stats are 95% end of default judgment. So those judges sit there most days with their clerks stamping these default judgments over and over again. I think there's some benefit at times, particularly depending on defenses you have, to get kind of a fresh set of eyes at this in a forum like a private arbitration, like JAMS or American Arbitration Association, to have them kind of give a fresh look at it. So if you're going to file it, like I said, you need to be prepared if the court grants it, which I think they should. You're just asking the courts to enforce their own, the creditor's own agreement. If they force that into arbitration, you need to be prepared to do it. I used to have kind of a different opinion on this. I used to say, look, if the court grants the motion to compel arbitration, the creditor should initiate it. And if they don't, the court should dismiss. Because it was always my thought, look, the creditor's the one who has the claim. My client doesn't have a claim. However, I had some judges kind of give us some grief for that approach. So nowadays when I compel arbitration, I immediately go and file. As soon as the court grants it, I go and I open up arbitration. Super easy to do. I pay my filing fee, and then the arbitration process takes over, and they reach out to the creditor. So I think that, one, that demonstrates your good faith in going forward, that you're ready to do this. And two, then it puts the onus back on the creditor to respond to it. And, they're going to have to come in, pay their filing fees, and be ready to go. So if you go to the website, I typically use American Arbitration Association. It's super easy, and they have it set up so, I mean, you don't have to be a lawyer or anything. They have a little button you just click that says start a case, and you can start the case in 10 minutes.
That's interesting. Okay, so once the motion to compel arbitration is filed, the judge can grant it, probably will. And then once it's granted, then somebody needs to initiate arbitration. For the initiation of the arbitration, does the judge usually tell someone to initiate it, or can the filer just proactively initiate usually?
Well, the process I see here in Arizona is the judge will compel arbitration. I've seen it one of two ways. Sometimes the judge will just compel arbitration and dismiss the lawsuit. I've seen other judges who will say, okay, I'm going to grant the motion to compel arbitration. I'm going to give you 90 days to initiate it. If you don't do it within 90 days, then the lawsuit's going to pick back up and we're going to set this thing for trial. So there's usually a window of time that it needs to happen in. And like I said, it's fairly straightforward. You don't even, it's different than a lawsuit. Like, you don't have to have a complaint or anything. Usually the only things you have to have, at least with AAA, to file arbitration, you're going to have a copy of the agreement that has the arbitration clause in it. They're going to require you to upload that so that they see that they have, a jurisdiction over it. And then you can just fill out, what the deal is. And I usually just put, this creditor filed a lawsuit against me. I want to have it dealt with in arbitration. The court ordered it. Here we are. And then they'll take it from there.
And you do that on the AAA website or the JAMS website?
Correct.
And
then they're really consumer friendly. So if you have concerns, people can go to those websites and just walk through the process of what it's like to file that.
Hannah, maybe you could stick those websites in the chat for AAA or JAMS. And then once it's initiated, even if the consumer initiates it in this case, AAA will reach out to the collector for the collector to pay the fee for arbitration. Is that right?
They usually just send out a letter that says, okay, hey, this has been initiated. They give the creditor a deadline to file any type of response and then to pay their fees. And then they'll assign it to an arbitrator who can either do it in person. They can actually do like a kind of an in-person trial, or sometimes the parties can agree to just resolve it through written motions, like a motion for summary judgment type thing.
Right. Nice. Okay, great. Let's see here. So we have about 5 minutes left. I'm gonna try to get some other good questions here. If we don't get to it on here, hopefully Hannah will be able to get to your question in the chat. Okay. Let's see. Is it legal to provide the defendant false information on the summons in order to attempt to obtain judgment for no response? For no response received.
So essentially saying that they served you and didn't, or I guess I'm not 100% clear on that.
Let's see here. Let's see. Got a little visitor here with me. So let's see. Is it legal to provide the defendant false information on the summons in order to attempt to obtain the judgment for no response received? Is that making sense on the second reading? Sometimes the questions are a little tough.
Sounds like to me probably the certificate of service, that they may have said that they served you or did something and that the process server didn't. So in just kinds of background, usually once the process server once they accomplish service, they have to go file a document to court that says, hey, judge, here's how I did it. And it's going to have the date, it's going to have the time, it's going to have the physical description of the person, the address, all that kind of stuff. And so the question, how I'm understanding is, what if they put something that's not true in there that results in a default judgment being entered?
Yeah.
And I have seen that. I'm not going to say that, we have to believe all process servers, because I have seen certificates where it's flat out not true. And we've proven it's not true. And, I once had a court say, well, what motivation does a process server have to say something that's not true? Well, most process servers work for individual, their clients or the attorneys, and their success is based upon them getting things done, getting people served. And so there could be some outside pressures. Again, I'm not saying that happens in all or even many cases, but I have seen it where they put something that's in the information there's not true. Here, the catch is that the hard thing is if the affidavit of service or that certificate of service is, once it's filed with the court, if you want to contest it, the burden now shifts to you to disprove it, which is always a hard thing to do because you're kind of proving a negative. You have to prove that something didn't happen. One example I can think of, though, one time we had a process server who said, hey, I served this person on, January 24th at 8:00 p.m. kind of thing. We actually were able to go back and show that my client was at a wedding. And the way we proved it is we had Facebook photos that were all, we actually pulled up their social media account and showed that they were across the country at that time. So the burden shifts to you then as the defendant to prove that what the process server said is not true. And you're gonna have to come in with something better than just didn't happen. You're gonna have to come in usually with some kind of extrinsic evidence to be able to prove that, which can be tough sometimes.
Yeah, and an important point here, right? So they're asking, Denise asked, is it legal? And I think a little bit of what she's getting at is sometimes I think consumers believe that if something has occurred to them that might be illegal, then they will automatically win because courts always execute the just end.
Yeah.
And I think it's important to recognize, Janice, that that's not the case, right? So it may have been like non-compliant or illegal or something wrong happened here, but ultimately nobody cares except for you. And that means, what I mean there is that you have to respond and protect yourself in court. Especially what I mean is that the judge isn't going to rule in your favor just because this happened. You have to bring it up to the judge, right? John oftentimes say that the judge isn't the referee. Like the judge isn't going to, if someone was served improperly or if the statute of limitations has expired and the consumer doesn't file an answer because the statute of limitations.
So you have to view it from the court's perspective. The courts are dealing with usually thousands of these cases, and they're not, they're not just piecing through each one to make sure everything's been done properly. Particularly in a default setting, they sign that thing and it's gone. They're on to the next one. So if there's something that's happened that you feel like the court needs to address, you need to raise it. Basically waving your hand, pointing, saying, look at this, this is what happened here. It may not be determinative of your case, but sometimes it can make it so the court can see, look, maybe we better pay a little bit more attention to this one because there's some kind of funny stuff going on.
Right. Great. All right, well, that's pretty much what we have time for today. John, we didn't get much into bankruptcy, but can you go ahead and just let the people know what they can use you for? Like who can come to you for additional services?
Sure. Yeah. Probably half of what I do is bankruptcy. Sometimes we fight a lot of these lawsuits, but sometimes, I say, hey, you can win the battle, but lose the war. If there's a lot of stuff going on, or if there's wage garnishments, bank levies, bankruptcy can stop all of that. So, and that's kind of how I got into defending debt collection lawsuits. And sometimes bankruptcy doesn't make any sense because we can just fight this one case and put you in a better spot. But sometimes it doesn't make sense to put a bunch of resources into fighting one case when there's 5 more behind it. And so if they're in, I handle only Arizona cases, but people can reach out to me. They go to the Consumer Warrior YouTube channel. All my contact information's there. I'll be happy to see how I can help.
Great. So even if they're outside of Arizona, they can reach out to you? You can't.
Yeah, they can reach out to us, and there's sources like you with Solo Suit that we refer people to. We also have attorneys in some other states that we refer people to as well, so we can at least be a referral source if anything.
Great, and John also has a series of really helpful videos that explain more about this process and help you defend yourself and resolve lawsuits on your own as well.
Yeah, absolutely.
All right. Well, good to see everybody. We had lots of people here tonight. I'm glad that we could answer a lot of your questions. Always remember, Solo Suit is in your corner. We're here to help you out. We want you to win. John, thanks for coming on.